Hello, and welcome back to my semi-comprehensive overview of legal practice areas. This is part 2, and if you haven't watched part 1 yet about litigation, please go back and watch that because I will be referencing litigation throughout the video to help you better compare and contrast the two. As a quick overview, remember that there are 3 major buckets of practice areas: litigation, corporate or transactional law, and regulatory or compliance. These practice areas are buckets because the other types of law that you hear about, criminal law, M&A, environmental law, all fall into one or more of these major buckets. I talked a lot about what a litigator does in part 1, but going to trial, discovery, yelling objection is not the only way of practicing law. If you ever thought that being one of those lawyers who yelled about closing deals and getting deals done was your calling, then this video is for you. Besides litigation, the next big bucket practice area is corporate law, or sometimes called transactional law. I know sometimes that corporate law is used to colloquially refer to all types of legal practice, including litigation or regulatory work on behalf of corporations, but we're beyond colloquialisms here. I'll refer to corporate law here the way that lawyers refer to corporate law, meaning excluding non-transactional matters. So when I say corporate law here, I'm not referring to representing a corporation in a litigation or helping them in some kind of regulatory proceeding, including getting a governmental license. Whereas litigation is all about disputes, corporate law is all about contracting or transactions to help you avoid future disputes. Lawyers sometimes talk about corporate and litigation as if they were dichotomous, but I actually think that they're more like the yin and the yang. Corporate law helps everyone get on the same understanding of what they want to do. And if it turns out that there isn't a common understanding, then it becomes a dispute, and potentially with litigation on the horizon. If the corporate lawyers do a good job, then it decreases the chance that the litigators will need to be called on in the future. Conversely, the court's decision in the trial run by litigators will impact how the corporate lawyers contract and draft in the future, to try and avoid whatever ambiguity or confusion that the litigators were litigating about. In this way, you kind of see how corporate and litigation form the circle of law, right? There's corporate drafting, which sometimes, if it's ambiguous or there's a dispute, leads to litigation, which impacts how the corporate lawyers draft in the future, and it kind of goes in a cycle. Let's get more specific about what exactly corporate law is, though. Law firms will structure their practice groups and their departments differently. Sometimes there's just one corporate group, or other times there is an overarching corporate department with various corporate subgroups within it, like M&A, tech transactions, fund formation, private equity, capital markets, finance and lending, however they want to structure it. It really is up to the law firm's leaders to structure their practice groups however they want, but usually there is a hard line between the litigation department and the corporate department. Whether a law firm has one corporate group or has an overarching corporate department with various subgroups underneath will depend on the volume and variance of corporate work that the firm gets. If a firm doesn't have a ton of tech clients asking them to engage in tech transactions, then it doesn't quite make sense to have a special tech transactions group. Likewise with fund formation or private equity. If there's not a lot of a particular type of group, then it just makes sense to have one corporate group who's responsible for all of the various other submatters. But let me back up. I'm throwing a lot of second level terms at you, and we haven't even quite covered yet what transactions are at issue. For that, we have to have a quick primer about corporations. Say we have 2 corporations, CC Corp and Nate Corp. There are a lot of transactions that CC and Nate can enter into. For example, CC could buy all of Nate's tangible and intangible assets so that CC effectively owns all of Nate. This would be an M&A or a merger and acquisition. Another type of M&A could be setting up a third corporation, say Yuna and Riku Corp, and then have Yuna and Riku Corp buy all of CC stocks as well as all of Nate's stocks. So Yuna and Riku then would effectively own both Nate and CC. There's various ways to structure mergers and acquisitions, and one of the fun parts as you get more senior in M&A is trying to figure out this deal structure. Another transaction that the two could enter into is lending money to each other. Maybe CC is in a period of financial trouble right now, but Nate is willing to step in and make a loan to CC in exchange for a corporate bond. Or maybe CC is looking to buy another corporation, let's say Twitter, and needs to secure the financing in order to do so. Nate might be willing to lend a certain amount of money to CC to help them secure the financing to buy Twitter. There's many more transactions that CC and Nate can enter into, such as selling ownership in their respective companies through an IPO or initial public offering or additional securities offering. This usually requires a bank to buy those shares first before listing them on the exchange. Or CC could license their intellectual property to Nate, which requires drafting a licensing agreement. Basically, anything that you can think of that requires more than one corporation or individual requires a transaction. And transactions require good contract drafting in order to minimize the chances of going to litigation. Why are contracts so important in corporate law? Well, contracts essentially memorialize all of the parties' understanding that what they're getting into and what they're going to do, as well as providing for contingencies that they're particularly worried about. At a really, really high level of abstraction, it's like a prenup between two corporations. You could also have a prenup between a corporation and an individual, such as an employment agreement. Even prenups themselves are contracts, which I know some people hate thinking about because it makes marriage seem more like a transaction. But after taking family law, I don't really think that transaction is a bad thing necessarily. Whereas in litigation, you win or lose cases, sometimes by decision of the judge or jury. In corporate, it's more a matter of how good you are at first, identifying all of the situations that your client cares about so that you can properly memorialize the risk allocation in the event of those what-if scenarios. And second, advocating for your client's best interests so that the contract covers most, if not all, of what your client really cares about. Litigation is primarily an adversarial game, but corporate is this weird blend of cooperative while recognizing that it could become adversarial. At this point, you might be wondering why corporate law is legal work at all, especially because it doesn't involve going to trial. And you wouldn't be alone. I know there's some litigation snobs out there who take the position that corporate law isn't real law, but I think that's a really short-sighted view of what law is. Law should be as much about cooperation and harmony as it is about disputes. And that's where good corporate lawyers really shine. Not all contracts are made equal. After you've spent some time practicing corporate law, it becomes really easy to identify good contracts and bad contracts. Just like normal writing or writing a brief for the court, there are customs and terms and structures that are unique to contract drafting. In the same way that you sometimes marvel over a beautiful paragraph in a book, a clever contract is similarly awe-inducing. You just gotta learn the language of contract drafting though, which is what being a junior corporate associate is all about. And when I say that it's another language, I mean it. Do you know what double materiality scrape, ring fence, reverse triangular merger, or STET mean? Yeah, neither did I before starting out the law firm. But that's okay, that's what your training is for, to learn this bizarre language of corporations. Okay, this has been very high level thus far, so let's walk through in greater detail what corporate lawyers actually do. I mostly interfaced with M&A, which I really think is my favorite corporate practice area, minus the lifestyle, which is a huge component of it. So let's walk through a hypothetical M&A as an example of what corporate lawyers might do in a transaction. Let's go back to my very first example of CC Corp buying Nate Corp. First, CC and Nate have to even be aware of each other to know that they could enter into a transaction. That's usually what the investment bankers do. Maybe Nate is looking to sell and reached out to an investment bank to help shop them around, and now the investment bank is shopping Nate around to potential buyers, including CC. Or maybe CC is just really aggressive and sends Nate a letter of intent to buy, which is what Elon Musk did with Twitter, even though Twitter wasn't looking for a buyer at the time. After CC and Nate decide that yes, they do want to enter into a transaction, it'll be up to the investment bankers to figure out a purchase price for the deal and the lawyers to figure out what the term sheet for that deal is. A term sheet basically states at a very high level the terms of the M&A. Even though term sheets are non-binding, parties generally like to enter into term sheets because of how long the definitive agreements are and how long it takes to negotiate them. Term sheets are a way for the parties to agree on the key points of a transaction so they know that further going down this M&A won't be a waste of time and money for everyone. After all, it would be really annoying to have spent millions of dollars negotiating the agreements, all to find out at the very end that there is an intractable term that the parties can't agree on, and everything completed up until then has been for naught. The term sheet is tailored to whatever CC and Nate care about, so the term sheet might look different than the term sheet for another deal. It'll include information such as purchase price for sure, deal structure, and likely other provisions such as indemnification caps, which is the highest amount that the seller can be liable to the buyer for in the event that the seller misrepresented themselves in the transaction. Survival period, which is the period of time after the transaction closes that the buyer can sue the seller for misrepresentations about something and still recover money. And exclusivity, which is just the period of time where the seller can't enter into other discussions with potential buyers. You can kind of see how even though we're talking about corporations here, there are parallels with human relationships, right? Like human Nate and human CC could enter into a prenup that says that in the event of our divorce, the most that we could owe the other in terms of alimony is 20% of our income or something like that. Or maybe we can only freely amend our divorce agreement for the first 6 months after our divorce, or we can't engage in talks about marriage with a third party when we're engaged. So the term sheet gets signed and then the deal kicks off. In an M&A, there are two key legal work streams. First, due diligence, and second, the definitive agreements. Workstream 1, due diligence, is when the buyer gets to do a lot of research on the seller. This due diligence request list will have a list of questions for the seller to answer, as well as a request for certain documents that are relevant to those questions. When I did privacy due diligence, for example, I would put things like description of the company's privacy and data security practices, or copies of all data protection agreements that the company has entered into. The corporate associate would gather all of these requests from the specialist attorneys, intellectual property, environmental, employment, privacy, and then synthesize these lists into one list to send over to the seller. Does this sound familiar? Because it should. It's a different context, but it's somewhat similar to litigators sending out discovery requests during pretrial. There's one major difference in posture between the two though. In litigation, the posture is adversarial. The recipient hates the requests, wants to trim them down, wants to delay. In contrast, in corporate, the recipient is somewhat motivated to get the information over to the buyer. The sooner the buyer has all of the information that they requested, then the sooner that the deal will close. And the sooner that the deal will close, the sooner that the sellers will get their money. Of course, there are times when the due diligence requests can get way too voluminous or out of control, and in those instances, the corporate team, along with the client, have to decide what they really care about and pick and choose or risk delaying the deal. Corporate transactions aren't about dominating the counterparty, remember? It's about cooperating to get the deal done. So here, Cece might send Nate a list of requests including provide a copy of your financial statements for the past 5 years, and provide a list of all outstanding litigation or disputes that you're currently involved in. Nate's lawyers would then provide answers to these questions, including documents that can serve as backup or evidence that what they're saying is true. Cece's lawyers would then review these documents to verify that what Nate is saying is true and that Nate doesn't actually have mountains of debt to someone else or is being sued by an ex-co-founder. Due diligence is really the time to deeply investigate all of the potential issues that the seller might have before the buyer decides to hitch their metaphorical wagon to the seller. As Nate's lawyers send out answers and documents over to Cece's lawyers, the junior associates on both teams will spend the time reviewing these documents, either before they go out or when they come in, to ensure that they are responsive and not revealing anything that might implicate other issues like privacy issues or confidentiality issues. The buyer's lawyers will review the documents to try and gain a deep understanding of how the company operates and how its legal risks are. Except there aren't search parameters or e-discovery platforms with coding panels. There's just one or a few junior associates clicking through board meetings minutes and contracts trying to find any major legal issues. Perhaps Nate has a huge contract that prevents it from selling itself to Cece because the contract is with one of Cece's main competitors. That could potentially be a deal breaker. Other deal breakers include an impending lawsuit that could open up the seller to a ton of liability, which the buyer doesn't want to buy and take on, or the environmental lawyers could discover that the licenses that Nate thinks it has to run its business Nate doesn't actually have, and that's a huge impediment to Nate's operation as a business. The intellectual property lawyers could also discover that Nate doesn't actually have the intellectual property that it purports to have, and that could be a huge issue, especially if the reason that Cece wants to buy Nate is for Nate's intellectual property. Even if they're not deal breakers, there's still issues that the buyer would want to know about. Like, maybe, yes, Cece is okay with taking on some of Nate's liability. After all, if Nate has student debt, maybe it's not a deal breaker for Cece, but it's something that Cece would want to know about in advance so that they can prepare for and plan for accordingly. So as teams of junior associates review these documents and contracts for issues, they'll have to make notes about these documents and contracts for either the more senior associate or maybe even the client. Deals can really vary in terms of due diligence deliverables. Sometimes clients will want really detailed summary charts, and sometimes they don't really care. I like to keep charts myself even if the client doesn't ask for it, because it helps me be a little bit more organized and find the information if asked by the client or partners more quickly in the future. When I'm supervising junior associates, I also like to ask them to keep summary charts because I think it really helps them fully understand the issues that they're looking for, as well as helps me review their work a little bit more easily. Not all clients will want a due diligence summary chart though, but 95% of them will want a due diligence memo. This is basically a summary of all the legal due diligence that the lawyers have done. Sometimes clients will want really detailed due diligence memos that include factual summaries of things as well as potential issues found. Other times the memo will flag only yellow and red issues. It really depends on the deal and the client, and sometimes clients will really want this in PowerPoint format, for example. When you're working as a specialist, such as an environmental lawyer, intellectual property lawyer, employment lawyer, privacy lawyer, you'll take your cues about what to do for your legal due diligence from the corporate team. Your due diligence will be limited to the scope of your practice area. So if you're in employment, you don't really have to worry about the environmental due diligence. I found that sometimes the corporate team is a little bit too overwhelmed to give clear instructions on how to complete due diligence, So it's always a good idea to, at the very outset of a deal, talk with the corporate team about what kind of due diligence deliverable the client wants, as well as how detailed the deliverable should be. It's always better to ask beforehand for clarification rather than to realize after sending out the whole thing that you've done something wrong. The corporate team will then compile everyone's due diligence memo sections along with their own corporate due diligence and send out one memo to the client. If you can't already tell, the corporate team serves as the main point of contact with the client and with the counterparty. Okay, that's the due diligence work stream. You request answers and a bunch of documents, review those, and then summarize the legal risks that you find for the more senior lawyers and the client. At the same time, work stream 2 is chugging along, the definitive agreements. I covered this in a section of a very early vlog, so let's do a quick refresher. Like we discussed before, when parties enter into a transaction, you need a written document memorializing all of their understanding about the transaction and preparing for any contingencies. The merger agreement is just that, a hundreds of pages long document that outlines the details of the transaction and states its contingencies. The merger agreement itself is very, very long, but a major area of focus in the merger agreement is the representations and warranties, or reps and warranties for short. They're basically promises to the other side about what you are. So here's where Nate might make a representation that they have no outstanding litigation or ongoing investigations or inquiries that might materially and adversely impact the company. Each specialist area of law, labor, tax, environmental, will have their own sets of reps that they will pay attention to. A large part of being a mid-level or senior associate or a partner is negotiating these reps and warranties. The negotiating posture is pretty intuitive. You want to negotiate weaker reps or weaker promises on behalf of your own client, so you're promising less, but you want to elicit stronger promises or stronger reps from your counterparty because you want them to promise you more things. The fun part though, at least in my opinion, is figuring out how to best advocate for your client in light of the unique bargaining power that your client has. If Nate is a hot commodity that a lot of other companies want to buy, then CC might have to concede on a lot of reps and warranties and other things in order to win the bid. But if no one wants to buy Nate, then CC all of a sudden has greater leverage and can ask for reps that are more favorable to CC. There's a certain dance that occurs, and figuring out how to negotiate as well as your own negotiating style was one of the funnest aspects of deal work for me. There were some partners whose negotiating styles I really admired. It had the same performance aspect as a really good opening argument or closing argument. The second part of the definitive agreements is called the disclosure schedules. The disclosure schedules are, well, disclosures against the agreement. So the merger agreement might say that Nate has no ongoing litigation or pending lawsuits, but Nate's actually being sued by a former co-founder. As long as Nate lists that lawsuit on the disclosure schedules though, we're fine. Nate's not lying about anything because he disclosed the lawsuit on the disclosure schedules. It's basically a get out of jail free card for any breaches of the reps. In addition to the merger agreement, the parties will also negotiate over the disclosure schedules and what to include in them. The seller will want to include more disclosures because it's a get out of jail free card, while the buyer will understandably want to have fewer disclosures. And how does due diligence, our first work stream, impact the definitive agreements, the second work stream? Well, how else would we know what to put in the disclosure schedules if we didn't do our research? The due diligence directly has an impact on the definitive agreements in that way. If there's a huge glaring issue that the buyer can't get comfort on related to due diligence, maybe the buyer will ask for a rep specifically on that point from the seller. So in this case, the seller making a rep as to something shifts the burden of being wrong onto the seller who is making the representation. For example, let's say that CC Corp is really concerned about Nate Corp potentially having outstanding speeding tickets in foreign jurisdictions. However, due to some reason or other, there just isn't enough information for CC to get comfort on that fact. So CC asks for Nate for a specific representation, a promise that they have no outstanding speeding tickets in foreign jurisdictions. If Nate does have speeding tickets in foreign jurisdictions, then Nate will have breached a rep, which may then give CC grounds to terminate the agreement or seek money from Nate. The due diligence could also impact what goes into the disclosure schedules. For example, maybe Nate puts down that they owe $20 to a friend against the rep that they have no material outstanding debts. CC discovers that $20 is not a material debt given all of Nate's total assets, so CC proposes to delete that disclosure. I think that due diligence and the definitive agreements are kind of like the yin and the yang of M&A work streams. Each affect the other, and the work streams need to be in constant conversation with each other. So that was only M&A. Other corporate practice areas may deal with things like securities offerings or fund formations, and they all have their own unique work streams, due diligence, and agreements. Someone once asked me what I got out of big law other than the money, and I do think that learning about corporations was the most illuminating thing, because seeing corporations in action really helped me contextualize their role in the US government, economy, and culture as a whole. Okay, now that we have a little bit of an understanding about what corporate law is, who is corporate law best suited for? Corporate law is a great practice area for people who can be detail-oriented but don't want to be as as detail-oriented as litigators. You'll still need to be detail-oriented because, let's be real, it takes a lot of attention to detail to go through all those contracts to try and find the one provision that might be a deal breaker. But there's a bit more wiggle room than in litigation. Filing a document that has errors with the court is a huge faux pas, but sending something that might not be entirely correct to your client or the counterparty, it's not great, but it can be fixed. Nothing is really final though until the deal closes anyway, so you're not as concerned about errant commas or typos. Whereas as you get more senior in litigation, your name is on all of the court filings, so you better know them inside and out and make sure that you can vouch for them. Corporate law is also great for people who like to have shorter sprints of work rather than long marathons. Remember that litigation can stretch out for over years, so you can work on one litigation for a long time. Corporate matters, on the other hand, tend to be shorter, a few weeks, a few months. And while it can be really intense during those few weeks or months, there's still an end at sight at all times. I found that for me, that was the most appealing part about corporate work. I'm a really impatient person, so being able to see the light at the end of the tunnel was always really motivating to me. I can grind it out as long as I see what the end date is, you know? So if you like those peaks and valleys and enjoy those shorter, intense sprints as opposed to longer marathons, then corporate law might be for you. If you want to one day go in-house or go into the business side of companies, then corporate law is also a better fit for that end. Yes, you can go in-house from litigation, but it tends to take longer, 4 to 7 years, and there are more limited roles for litigators at companies. In contrast, I've seen corporate associates go in-house as early as their second year, and the sweet spot tends to be 3 to 5 years at a firm. There are also way more corporate positions at companies because corporations engage in transactions all the time. Corporate practices also expose you to the business side of companies, so it's not uncommon to see corporate lawyers pivot into business roles at companies. Even general counsels tend to have a lot of non-legal responsibilities. If a company has a lot of litigation, then they might have a specific litigation general counsel, but it's usually not a position that a lot of companies want to be in because they do not want to be embroiled in that much litigation. I also think corporate is a good choice for people who really like conducting deep dives on companies, like banks, tech companies, and consumer goods companies. You learn a lot about a company during due diligence, and sometimes it can be really surprising how a company operates and what's important to a company. Litigators also have to review corporate accounting statements, but I think corporate lawyers do it because they find them at least a little bit interesting, whereas litigators are doing it with a purpose, usually to identify fraud. In other words, litigators look for the gotcha moments of corporations, whereas corporate lawyers genuinely want to understand how a business runs. Finally, I think corporate law is well suited to people who like to talk to others and try to agree on things. I know that seems a little counterintuitive because litigators are the ones to talk in court, but the litigators are performing. The corporate attorneys are more discussing. I think there's a difference, and whether you want to perform more or discuss more says a lot about what your natural inclination as between litigation and corporate might be. Not saying that it's an end-all be-all litmus test, because both types of law involve both performance and discussion, but just what you may be naturally inclined towards. I know that I found the posture of litigation to be grating and anxiety-inducing, and I much preferred the dynamic of corporate law and regulatory, which I'll talk about in my next video. And there you have it. If you're a corporate lawyer and want to talk about your experiences, feel free to drop them in the comments below. And stay tuned for the next video about my favorite practice area and what I actually did practice in, regulatory.